How do you analyze logical relevance on an evidence essay question? Well, step one on any evidence essay question is going to be to determine whether each piece of evidence that's being introduced is logically relevant. This is your gateway issue on an evidence essay question. So for each piece of evidence that fact pattern is trying to introduce, you're going to have to run through this analysis to determine whether each piece of evidence is actually logically relevant. If it's not, if you find that a piece of evidence is not logically relevant, then of course that means it's inadmissible. It cannot be admitted. So how do you make this determination? Well, you're going to have to ask for each piece of evidence, whether it's probative, and whether each piece of evidence is material. If a piece of evidence is both probative and material, then it is going to be logically relevant. But if either of these elements fail, it's not probative or it's not material, then it's going to not be logically relevant. And of course, that piece of evidence is then inadmissible. It cannot be admitted. Okay, so how do we determine whether a piece of evidence is probative and material? For probative value, your first element in this test, what we say is if the piece of evidence that's being introduced has any tendency to make a fact more or less probable than it would be without the evidence, it is probative. And if that fact is of consequence in determining the outcome of the action, then we say it's material. Sometimes I call the material element of this test the do we care test. Do we care? Whether a piece of evidence is material, what we're really asking is, do we care? Does this help the jury come to a conclusion? If the fact is of consequence in determining the outcome of the action, then we care, right? It is material. If it's not, if it has nothing to do with the outcome of the action, then we don't care, right? It's not material. So sometimes I call this idea of whether evidence is material, the do we care test. And we'll break this down though with some examples, right? This is the easiest way to see how this all plays out. So I have an example drawn up here. Let's run with this. So we have a plaintiff suing a defendant for negligence. Let's keep it very simple. Let's say that we have a car accident and the plaintiff is alleging that the defendant ran a red light negligently and hit the plaintiff in a car, right? So that impact caused the plaintiff damage. Plaintiff is now suing defendant for negligence to recover his damages, okay? And let's say that the plaintiff wants to introduce eyewitness testimony. Let's say we had a witness that was at the scene of the accident, and that witness is going to testify that the light was red when the defendant ran through the intersection and hit the plaintiff's car. So what's our evidence here? The evidence being introduced would in this case be eyewitness testimony. We have eyewitness testimony. And what is the fact being alleged here? That the light was red. That the light was red. Okay? And so if you're on an evidence essay, and you want to ask whether this eyewitness testimony is logically relevant, what are you going to do? Well, you have to ask, is this eyewitness testimony probative? Is it probative? And is it material? Remember, in order to be logically relevant, it has to be both probative and material. So what is probative? Does this piece of evidence, this eyewitness testimony, have any tendency to make the fact that the light was red any more or less probable than it would be without the eyewitness testimony? In this case, yes, right? Eyewitness testimony in the eyes of the law is very strong form of evidence, right? The court and juries value eyewitness testimony very high. So this has a very high probative value. We have an eyewitness who's coming to court and saying, I saw with my own two eyes that this light was red when the defendant ran it. When that defendant went through the intersection, I saw the light was red. Okay, so that has a tendency to make the fact that the light was red much more probable than it would be without that eyewitness testimony. If we didn't have this eyewitness testimony, how do we know the light was red? We don't. This eyewitness is coming in though and saying, I saw it with my own 2 eyes. So that has a very strong tendency to prove the fact that the light was red. So we say it is probative. The next question is going to be, is this eyewitness testimony material? Is this testimony, is this fact rather, that the light was red of consequence in determining the outcome of the action? Do we care if the light was red? Yes, obviously, this is the heart of the plaintiff's case. If the light was green and the plaintiff runs through a green light and there's an accident, how is the plaintiff negligent? This is directly of consequence in determining the outcome of a negligence action. The plaintiff's entire case is centered on the fact that the defendant was negligent because he ran a red light. That was his breach of the duty, right? So the fact that we have an eyewitness coming in and saying that the light was red is extremely material. That goes to the heart of the plaintiff's case. The fact is of consequence in determining the outcome of the action. So it's material. So this type of evidence right here, an eyewitness coming in and saying that the light was red in a negligence case where the plaintiff is alleging that the defendant was negligent and hit the plaintiff running a red light, that's going to be extremely probative, extremely material, no question about it. That is logically relevant, okay? So let's soften this up. Let's keep the exact same example, but let's make it a little bit trickier, right? Because if logical relevance is tested, if your grader or your examiner wants to test your knowledge of logical relevance, it's never going to be that easy, right? So what if the witness, same exact fact pattern, but instead of the witness saying, I saw it with my own eyes, I'm 100% certain that that light was red, what if the witness comes in and says something like, well, I can't be certain, I wasn't wearing my glasses that day, but I'm pretty sure that the light was red. I can't be positive, but I think the light was red. So we make the fact, so now what happens here? Same fact, the light was red, same eyewitness testimony, but now the eyewitness testimony goes down from, I'm sure the light was red to, I think the light was red. Can't be certain, but I'm pretty sure the light was red. Okay, well let's run through. Does that evidence, does that eyewitness testimony have any tendency to make the fact that the light was red any more or less probable? Yes, it has some tendency, right? It has less tendency now, but it still has some tendency to prove that the light was red. I mean, the witness can't be sure, but he still is saying, I'm pretty sure it was red. That has probative value. It has less probative value, but in that case, as long as he's at least more than 50% sure, right, then we have a fact that's being made more probable by the evidence. That eyewitness testimony is now going to make this fact that the light was red more probable. So it does have probative value. Even if it's a smaller amount of probative value, there's still probative value. Sometimes we refer to this idea as you don't have to be a star witness to be a relevant witness, right? It doesn't matter if somebody isn't committing with 100% certainty. You can still be relevant. You can still have probative value without committing 100% to something, right? So the idea that you don't have to be a star witness to be a relevant witness is really at play in a situation like this where we have a witness saying, I don't know, I can't be sure, I wasn't wearing my glasses, but I do think the light was red. Okay, that has probative value. Is it material? Yes, right? The fact hasn't changed. We're still proving this fact that the light was red. That is still going to be very material. Yes, we care whether the light was red. It doesn't matter how sure the witness is as to whether the light was red or not. It's still extremely material. This is still the heart of the plaintiff's case. Even if our threshold probative value level has dropped a little bit, the material aspect of this evidence is still extremely high because whether the light was red goes to the heart of the plaintiff's case. This is of consequence. The fact of whether the light was red is of consequence in determining the outcome of the action. So in that case, even if the eyewitness says, I can't be sure, but I'm pretty sure the light was red, we're going to say that that is logically relevant. It has some probative value, it's material, okay? Now, let's say that instead of saying, I'm pretty sure, or I think, or I can't be certain, but I'm pretty sure the light was red, let's say that now the witness actually says, he's asked by the plaintiff's attorney, was the light red? And he says, I don't know, I'm 50% sure. I am 50% sure. I'm 50-50 that the light was red. Well, does that have probative value? No, right? This evidence, that eyewitness testimony that he's 50% sure, has no tendency to make this fact that the light was red any more or less probable. By its definition, that's what 50% means. Doesn't make something more probable or less probable. It's a coin flip. We don't know. So in that case, if an eyewitness is going to get up there and actually say, I'm 50% sure, that's not going to have probative value. Is it material? Yes. So no, it's not probative, but it's still material, right? Whether the light was red, it's a fact we still care about. It doesn't affect the material nature of this evidence. We care whether the light was red. That is a fact that is of consequence in determining the outcome of the action. But now we don't have any probative value with this eyewitness testimony because he's saying he's 50% sure, which means he doesn't know. So there's no probative value. So that evidence, that eyewitness testimony, would then be not logically relevant. So it would be inadmissible. Can't admit that type of testimony. Now, what if instead of 50%, this witness says he's 49% sure? He's 49% sure that the light was red. Now, does it have probative value? Yes, right? Because the test, remember, even though this is the plaintiff's witness, and that testimony might hurt the plaintiff's case, well, it is still probative. We don't care who it hurts or who it helps, right? It makes the fact that the light was red less probable. He's 49% sure. That's less than 50%. That makes it not a coin flip. He's saying, I'm more sure than I'm not that the light was not red. He's 49% sure, so that has probative value. Again, it's material, of course, so that would be admitted. This is a fact, whether the light was red, of consequence in determining the outcome of the action. So we say it's material, it's probative, that is logically relevant. Okay? So that is pretty much all the variations that you could see of probative value. Let's throw in one more. Let's say that instead of eyewitness testimony, let's say that the witness now says, he doesn't say, I was at the scene and I saw it with my own two eyes. The witness says, I had a dream the night before the accident that the light was red. So the fact is still the light was red, but instead of eyewitness testimony, now the witness is saying, I had a dream that the light was red. Well, does the fact that the witness is saying I had a dream have any tendency to make the fact that the light was red any more or less probable? No, right? Having a dream has nothing to do with whether the light was red. So that eyewitness testimony, or that non-eyewitness testimony, this testimony of having a dream, does not make the fact that the light was red any more or less probable, doesn't do anything. So in that case, we would have no probative value. It's not logically relevant. Of course, whether the light was red, remember, that's still material. That fact is of consequence in determining the outcome of the action. But saying you had a dream that the light was red is not probative. Okay, so that's what you want to look out for in logical relevance when you're thinking about this first element. Somebody is so unsure or so non-committal that they're actually saying they're 50% sure, they're on the fence, they're not making that fact any more or less probable. In that case, it's not going to have any probative value. If it's something like what I just said, like a dream or a premonition, or something that's not actual eyewitness testimony, then of course it's not going to have probative value, okay? Now let's play with this second element a little bit more, whether the evidence is material. So here, let's say that, same fact pattern, let's keep it easy, but this time let's say that the plaintiff is calling the same witness, but rather than asking a direct question like, was the light red, an open-ended question is asked. And the plaintiff's attorney asks the witness, describe the events that happened that day. What led up to the car accident? So the witness gets up on the stand and says, well, I woke up that morning and the first thing I did was eat a stack of pancakes. Okay, and you have an objection right there. So we have a piece of evidence. We have eyewitness testimony to the fact that the witness ate pancakes, right? So we have an eyewitness account that the witness ate pancakes. He's getting up there and he's saying, well, I woke up that morning and I had me a stack of pancakes. So we have eyewitness testimony of a fact of eating pancakes. Well, is this probative? Yes, okay. Eyewitness testimony, he's not getting up there and saying, I'm 50% sure I ate pancakes that morning. He's not saying I had a dream that I ate pancakes that morning. He's getting up there and saying, I ate pancakes that morning. He's saying, I saw it with my own two eyes. I sat there, I cut up the pancakes, and I put them in my mouth. So that has a tendency to prove that he ate pancakes that morning, right? The eyewitness testimony has a tendency to make the fact that he ate pancakes that morning more probable than it would be without the testimony. Now, of course, where does this run into a problem? The do we care test. Do we care if you ate pancakes that morning? Is that of consequence in determining the outcome of a negligence action? No. Whether a witness ate pancakes or a turkey sandwich that morning, it doesn't matter. This fact of eating pancakes has no consequence in determining the outcome of a negligence action. We do not care what the witness ate that morning. Do we care? No. The jury's not going to care. No one cares what this witness ate that morning. So yes, it is probative. This eyewitness testimony he's giving does tend to prove the fact that he ate pancakes. So we can say, yeah, it's got probative value, but it's not material. No one cares, right? It's not of consequence in determining the outcome of the action. And of course, we could play with these facts. You can play with the fact patterns all day. What if it turns out that this witness somehow has got this bizarre allergy to pancakes that can affect his eyesight? So he's got some unheard of condition. We have a doctor that can testify to it, whatever. Then is it material? Well, yeah, now it matters, right? If you're telling me that eating pancakes in the morning can affect this witness's eyesight, well, then that is of consequence in determining the outcome of the action. The credibility of a witness is always material, right? That is going to be of consequence in determining the outcome of the action. How much credit we give this witness. So if he's got some bizarre allergy that makes him colorblind if he eats pancakes, then it's extremely material if he ate pancakes that morning. And it has a lot of probative value, right? Same thing. Eyewitness testimony saying he saw himself eating the pancakes, that is going to make the fact that he ate pancakes more probable than not, so it's probative. And in that case, if he's got an allergy that would affect his eyesight, he goes colorblind if he eats pancakes, then that is of consequence in determining the outcome of the action. So in that case, we would say, yeah, that's material, that's probative, that's logically relevant. Okay? And remember, in conclusion, to wrap this up, just because something is logically relevant doesn't mean that it's automatically admissible. This is simply the first step. It's the first hurdle a piece of evidence has to overcome. Now, if we find that something is not logically relevant, then we do automatically know that it cannot be admitted. It's inadmissible. But on the flip side of that, if we find that something is logically relevant, all that tells us is it's gotten over the first step of our analysis and we have to keep going. There's still other ways that piece of evidence could be found to be inadmissible. We have to continue the analysis. And that's what we're going to move on to in our next videos here. But with that, I wish you all the absolute best. I hope this video was helpful, and I'll see you at our next video.